So this is lecture 1. Lecture 1, we are going to consider the security risk arising from sales of ships and ships under construction in Asian shipyards. Alright, 这个题目是建好的和建造中的船舶买卖安全风险。This is lecture 1. Asian shipyards are referred to are mainly in China, Japan, and Korea. And the cases that tonight I'm going to analyze will be Korean cases plus Japanese cases. China, as you know, is a major shipbuilding country.
许胜光教授，本讲的主题将是建造好的和建造中的船舶买卖安全风险。许胜光教授是《海运法、海上货物运输和海上保险的主要问题》一书的作者。他在新加坡国立大学和纽约大学教授了3年国际航运法的双学位课程。许教授曾经是船东互保协会的法律通讯员，并被聘为大连和上海海事大学的客座教授。目前许教授在新加坡和温哥华都从事法律工作，并且是亚洲律师事务所的高级顾问。
Thank you very much. My teaching assistant, Feng Ying, thank you so much. So my lecture, the 内容 I'm going to split into 2 parts. First part will be discussions of English cases involving Asian shipyards, English cases. Then 2, I will have a comparative note between English and PRC cases. PRC cases are referred to China, involving security risks. Security risks are 风险, right? Now, the preliminary issues. Firstly, what are the preliminary issues? Preliminary issues are 主要议题, right? You must always remember, shipbuilding contract is a sales of future goods, because the ships has not been completed yet. And tonight, I'm going to speak mainly in English, as different from other lectures, because tonight I know there is a predominant presence of students from Watson, Fata, and Beta, and their standard of English is definitely of a very high level of proficiency. Now, bills of sale is a document to evidence the sales of the ships. Now, property passes upon completions of the entire hull. Hull is the ship's 船舶. Now, a ship is a chattel, it's a property. It is also considered as part of goods, right? Now, the general principles of the law of contract, 合同法, and plus English legislations relating to the sales and supplies of goods are applicable to sales of ships. Now, sales of ships in Taita is completed, and they use some very standard forms, such as the Norway Mai template or the Japanese one. And the Singapore one, you have the selections of Norway, Singapore, and the Japanese one. So sales of ships are transferred under such standard forms. And just to let you know, and this is something very interesting in English language. When you talk about a ship, we call her a she. She is a lovely ship. We are going on board her, and we are going to load containers on her. A ship is referred to as a she, and her, and this is unique to a vessel, right? Now, the next slides will be all in Chinese, and Fong Ying will read for me. Slide number 4. Can you hear me? Can you hear me? Yes, Fong Ying? Yes. Read. Okay.
Sorry. So, 船舶建造买卖合同是针对未来货物的买卖合同，卖据是指整个船体建成后的财产凭证。船舶是一种动产，同时也被视作为一种货物。那么，合同法通则和英国有关货物买卖的主要法律是适用于船舶买卖的。所有权的出售与转让是由标准的格式合同来完成的，比如挪威买卖合同格式或者 NSF， 日本和新加坡的买卖合同格式。
Now, let's talk about some preliminary issues. What are the preliminary issues? One, the building materials and equipment earmark, not part of the contract, unless appropriated to the hull of the ships, meaning that when you build the ships, you need to have a lot of building materials, right? Equipment, then they are not part of the contract yet, unless they are appropriated, means fixed to the hull of the ships. They must be fixed to the transport, then it becomes part of the ship's, part of the hull. Now, novations of shipbuilding contract, possible with the consent of the shipbuilder. Novations means that you transfer the shipping contract from A to B, if it is possible, if the shipbuilder has no objection. And just to let you know why I emphasize on this course, why I want law students to show an interest in this, because of all the cases involving Chinese shipbuilders 在英伦海事法院，包括英伦的海事仲裁院 Chinese cases 赢的机会 last 10 years 没有超过5%，没有超过5%， right? So show an interest and see how we can change the situation. Now, shipbuilding contracts, there is a guarantee called refund guarantee, and this refund guarantee is given by the shipbuilder. Shipbuilder is referred to as the 船厂. They also known as advance payment bond or guarantee. Recourse to ship owners to claim installment payment due to liquidation or major default like unreasonable delay, because the shipbuilder has to give the ship owner a guarantee document, and that is known as a refund guarantee. A refund guarantee is unique to shipbuilding contracts, okay?
Hello, Professor.
Yes.
定的造船材料和设备并不是合同的一部分，除非它是被用作船体建造的。造船合同的变更应当经造船方的同意。还款保函由造船方提供的，又称预付款保证书或者预付款保函。 那么船舶所有人因清算或者不合理的延迟等重大违约事由而要求分期付款的追偿。
Now, a nature of a ship sales. Okay, then ship sales talk about 船舶买卖的合同 and it's really in between the sales of goods and conveyance of real properties. Sales of goods, sales of goods. Okay? Conveyance means 房地产. So a ship sales is between two kinds of contractual matters, sales of goods and conveyance. Now, what is the statutory definitions of a ship? A vessel includes any ships or boat or other description of a vessel used in navigation and not propelled by oars. Now, what is the consideration of ship sales? The considerations is the price, right? Definitely, 买卖的价钱. Then property can also pass in the future, contingent upon satisfaction of some conditions.
船舶买卖的性质是介于动产买卖和不动产买卖之间的。当满足某些条件的时候呢，所有权的交付也能够在未来实现。
Preliminary inquiries. Now, we always have to find out if you're representing the shipbuilder. 假如你是船厂的律师 then you have to be very careful to know the 船东的名义财务情况，对吗？ Then check if the vessel is entered with a P&I club. P&I club is known as 跑赔协会，是一种保险来的 meaning that the funds are contributed by the ship owners and then a management is appointed to look after the fund. That is called P&I club. P&I club 是保赔协会。So maintenance of a class is the same as maintenance of vessel. A vessel is a floating asset and the buyer may want to conduct a survey on her. See, I remember, I don't say it, it's her.
在进行出区询问的时候，双方主要关注于船东的信誉、财务状况和船舶特征身上。
That's very important, right? You must know the reputation. Now, seller is the person selling the ships, all right? Now, the seller of the ships, you will have to have a duty to deliver the vessel at a particular date and a particular port, right? This is completed ships, right? 是在哪一个港口呢？ Anyway, just to let you know, this is very interesting, and I can see that one 北大学生 from Ningbo is attending the lecture. Now, you may know that 世界最大的船东是宁波帮，全世界最大的船东是宁波帮 and I am very lucky to be acting for all of them. They are both my friends as well as my clients, right? Then number 2才是希腊船东。希腊船东大部分不是在希腊，他们在伦敦。全世界最大的船东都是第一宁波帮，中国的宁波帮。大部分的宁波帮在哪里呢？在新加坡，在香港那个地方， 还有在台湾省、宁波邦，还有一些在温哥华 ，right? So the remedies of an unpaid seller can exercise possessory lien over the vessel as she is still in his possession. Now we will talk about possessory lien at a coming lecture, right? Then higher than a maritime lien in the determinations of priorities and judicial sales. We will talk about maritime lien, right? 留置权 in the next lecture. And when I was a shipping lawyer in London or in Singapore, when after arresting a ship, we have to sell her. And then we have to determine priority, number 1, number 2, number 3, number 4, number 5. Different from 房地产. Now, you know that mortgagee in a property sale, the ranking is very high, right? 你买一间屋子，你抵押给银行，银行的权利很大，但是你买一艘船呢，你抵押给银行，你权利不是很高，本是相当低，所以跟房地产不一样。
需要特别注意的是，造船方的留置权的受偿顺位，在司法拍卖中是高于船舶优先权的。
Okay, the buyer's rights and obligation. 那么买方有什么权利呢？还有什么义务呢？ Of course, number 1, to make payment for the vessel. And if the seller refuses to sell, what can you do? Then the buyer can claim the difference between the sales price and the market price, which he has to pay for a substitute vessel. 这很重要 right? If the seller refuses to sell, he will buy another vessel from the market and then claim any difference in the price. A buyer is under a duty to mitigate his damages at all material times. Can also 申请法院 for specific performance.
如果卖方拒绝交付船舶，买方可以主张合同价格与购买代替船舶的市场价之间的差价赔偿。
Now I will quickly discuss this case. Then after that, I will ask 方素心 to 分析这个案例. It's very interesting. It has to do with refund guarantee and has to do with 6 ship owners enter into 7 identical shipbuilding contracts with a shipyard called Jinsei Shipbuilding Company. Applicable law is English. Now, just to let you know, for maritime law, whether it is the contract is made in China or Japan, it is always applicable law is English. Now, ship contract provided for a full refund of all the advance payments in events of shipbuilders liquidation, means 船厂破产的 refund guarantee given by a Korean bank, right? And the Korean bank refund guarantee, the wording 条款 is the same as the shipbuilding contract, but they missed out on the issues of insolvency, means 破产. Now I come to 12, then I ask Susings to discuss this case. Okay? Now, it went up all the way to the UK Supreme Court. All the way to the UK Supreme Court. Okay? And I will now ask Fang Susings to analyze this case.
Okay, thank you, Professor. So, 今天我大概会用中文给大家做一下这个案例的分析。这个 case 的名字叫做 Rainy Sky SA and Others vs. Coming Bank。然后这个案子涉及在英国合同法下如何翻译合同的问题。 我将从4个方面分析这个案子，一个是事实，然后争议，然后最终的判决以及对后事的影响。在事实的方面呢 ，remedies 是5家向韩国金色造船厂订购船只的公司之一。remedies 和金色签订的合同约定，如果发生各种事件，如船舶交货迟延或性能不佳，或船舶在交货前丢失 remedies 将有权解除合同。如果金色造船厂破产，它应该通过3方保证，也就是通过通过国民银行的保证，向 remedies 退还付款，但合同并不因此解除。此处这个保证合同当中，约定的是根据合同remedies 在拒绝船舶终止、取消或撤销合同时，或船舶完全灭失时 remedies 有权得到交货前的分期付款的返还。然后此时呢，金色造船厂遭遇了财务困难，并进入了破产程序。然后 remedies 已经支付了2笔所需款项，因此 remedies 要求其退款。但是由于金色造船厂已经破产无力支付，所以 remedies 要求国民银行履行保证。所以本案的焦点在于如何翻译保证合同当中的所有此类款项 all such sums。金色造船厂破产无力偿还债务时，国民银行是否应当承担保证责任？国民银行声称它没有义务承担保证责任，因为该保证只涉及了船舶的拒绝收货、终止、取消和撤销合同。原文是这么说的：是 rejection of the vessel in accordance with the terms of contract, termination, cancellation, or rescission of contract, or upon the total loss of the vessel。所以此处金色破产并不涵盖在其中。经过了高等法院、最高法院的相反的判决之后，最高法院判决了remedies 胜诉。因为保证合同当中的第3段的所有此类款项 all such sums 有2种理解方式。高等法院此处为商事法院，它解读为所有的类似款项；上诉法院解读为特指第2段当中所指的款项，即拒绝收货、终止、取消、撤销合同或完全灭失。最终，最高院的科道大法官给出了判决，他援引了 Cooperative Wholesale Society Limited versus National Westminster Bank PLC，in 1995。他接受其中的一个原则，也就是当事各方约定用语明确时，法院必须适用，无论结果在商业上多么不合理。然而，在双方约定不明确的时候，含混不清的时候，他认为应该援引另外一个 case， Berkeley Bank PLC versus HHI Luxembourg SARL 这个 case， 它其中有一个测试，一个 test， 就是法院应当选择最具有商业常识的解释，也就是最具有 commercial reasonableness 的解释。因此，最高法院一致裁定，只要当事人使用的措辞不只有一种可能的含义，那么法院就有权选择最符合商业常识的理解，并拒绝其他理解。此诉金色造船厂破产是最需要保证实现的情形。那么将保证合同理解为可民银行需要履行保证义务，是最符合商业常识的。这个案子的影响就是这样裁决使得在对合同解释有争议时，要以商业上合理的合同解释为准。同时，法院并没有将此项原则限制为具有担保和赔偿性质的合同，相反，它明显是用于合同的一般性解释，因此它在所有的普通法地区国家的合同解释当中都具有最高的权威。当法官或者法院没有商业经验的时候，如何判断商业的合理性，则有时候会通过双方提供专家或者其他证实来提供。So that's it， 我的分析到此结束，然后我等会会把这个稿子发到群里面，大家可以看。
分析的很好，苏欣 ，very good。Right， 你看那个 slide 12，最重要的是这一段。The commercial purpose of the refund guarantee should be given more weight than the niceties of the language, right? nicety of the language. You must look at the overall picture. I am very interested in this case, extremely interested in this case, right? Now, then another one is a Japanese case. Here, it was whether the provider of the refund guarantee was liable to make payment of all advance payments to the beneficiary because there has been a novation of the shipbuilding contract. Novation means it's like a transfer of the shipbuilding contract for the construction of dredger by a Korean shipyard from the original company. Right? Then the guarantor not concerned with the facts of default but only with documents. Under Korean law, all rights and obligations were transferred to another company set up by the original entity. Then it was decided the guarantors were liable as the owner's demand for refund was made in conformity with the contract and the shipbuilder had failed to make the refund. Right? 我看中文的。
这个案子中，在建造挖泥船的造船合同债务人变更为一家韩国造船商的背景下，退款担保人是否有责任向债权人退还所有的预付款呢？担保人是不关心违约事实的，他只关心相关的单据。那么根据韩国法律呢，在债务转让的过程中，新债务人将承继先债务人的所有权利和义务，因此得出的判决就是担保人应当承担相关责任，因为船东的退款要求是合法的，在造船商未能进行退款的前提下，担保人有责任退款。
Okay, another one. 又是一个韩国的一个案例 right? So the important thing is that it is prudent of the shipbuilder to obtain a banker guarantee, a performance bonds from the shipowners to ensure remittance of progress payments when the shipping industry is in doldrums, meaning that the shipyards will give the guarantee called refund guarantee, but the ship owner will have to give to the shipyard a banker's guarantee, and that is called performance bond, right? Here, 3 Greek ship owners jointly, they provided a letter of guarantee to Korean shipyards to guarantee payment by a Liberian ship owner for the construction of ships, right? Here, it's not given by the bankers. 三个希腊船东 give a letter of guarantee, right? Letter of guarantee 保函. Then there was a default, and the shipbuilders canceled the contract and claimed for damages instead of recovery of the second installment. The House of Lords, Sumi Yen, said that the ship owners' liability for payment of the second installment payment was a liability before rescission. This was in addition to remedy of damages. Okay? Now, 16中文。
在这个案子中，谨慎的造船商通常会通过从船东那儿获得银行的担保和违约保证金，以确保在行业不景气的时候仍能收到货款。那么3名希腊人共同并各自向韩国造船商提供了担保，保证内容为1名利比亚船东的应付款项。然后船东方发生了违约，造船商解除了合同，并主张损害赔偿，而不是讨要第2期的货款。商业院认为呢，第2期的货款的债务产生于合同解除之前，应当作为损害赔偿请求权之外的补充。
Now, another 案例，这个是1980的英国案例。Now, failure to take delivery, right? Failure to take delivery during the sluggish times. Sluggish time 就是那个经济情况不好，目前就是 sluggish time 了 ，right? Then because then the 传统 要找借口了，违约。Now the vessel was actually built in another shipyard. That shipyard was a Osaka shipbuilders 的子公司。And the tanker owners, they did not want to take delivery. But Lord Denning, the very famous judge, said, it's okay. Everything was the same. The shipyard, the ship was built in a sister ships, 就是也是姐妹公司的船厂，不是 Osaka shipbuilder. Then sufficient that the vessel to deliver would be in substance the vessel described in the charter. Charter 是租船合同。
丹宁勋爵指出呢，所交付的船舶应当在实质上满足租船合同中确定的要求。
Now, insurable interest. Very important to discuss 保险利益 right? Mortgagee's interest protects financier for purchase of completed ships in the event of the insolvency of the ship owner. In other words, to protect, right? Now the other parties includes institute builders, risk, all these are various 保险的很多种保险 all risk 的一切险 right? Attachment takes upon delivery of the allocated items to the ships, not cover 地震 volcano eruption, or cover faulty designs, sea trial, change of interest due to novation of the shipbuilding contract. 是 mortgagee interest policy. 谁买 mortgagee interest policy 呢 is usually the financial institution, 好像金融公司还是银行，他们为什么要买这种保险呢？就是要保护自己 right? Especially right now, in today's period, especially right now.
抵押权人利益政策保护了在船舶所有人破产时购买完工船舶的权利。其他政策呢是包括各种协会建设者的风险，全保范围包括在此保险期间损失或损害的被保险标的物的损失或面试的所有风险。被交付给船厂时，抵押物就产生了。风险中并不包括由地震或火山爆发而造成的损失或灭失。风险是包括由于造船合同的更新而引起的设计缺陷、失衡和利益变更。
Okay, the MOA 就是 Memorandum of Agreement in China, right? China, as I say, follows the Norwegian sales form when building ships for foreign ship owners, and very popular with Japanese and Taiwanese ship owners. Some of them prefer the Norwegian form, right? But there are also other forms created by CMAX. CMAX is 中国海事仲裁 and then Shanghai form created by Shanghai Shipping Exchange and China Ship Owners Association, and they have used something created in China too.
其他形式呢，主要包括中国海事仲裁委员会起草的格式合同，由上海航运交易所和中国船东协会起草的格式合同。当事人呢可以选择适用中国法。
Now, applicable law, PRC, if it's a contract, then it have to be Chinese law and general principle of civil law, right? But if it is England, then the applicable law will have to be 三种宪法 sales of goods, supplies of goods. Now, if the buyer in PRC is obliged to inspect the subject matter throughout the sales period in the contract for sales of a ship. The buyer in China, they have to get people to inspect the quality of the ships. If the breach is serious, it will be a repudiatory breach, means that 可以违约. If the buyer is aware of the defects and is given the opportunity to inspect the vessel, and he cannot find the obvious defects due to his own negligence, there will be no liability on the part of the seller.
这个对的是，若违约足够严重，则会构成真的违约。
Non-delivery. What happened is non-delivery. Non-delivery due to force majeure in China is what is force majeure? Something in contract law as unforeseeable. Right now, right? Using the 新冠病毒 created force majeure, very likely in many situations. Right? Is something unavoidable and insurmountable, there must be timely notification. 这个是中国大陆的合同法. If it is unavoidable and insurmountable, you must notify the other party. No defects in title or claims from a third party. The buyer is obliged to fulfill his obligation to any charter party under the Maritime Code of PRC. Right? If the buyer accepts the deposit and is the defaulting party, he will return the deposit. If the buyer accepts the deposit and if the buyer is the defaulting party, he will have to return the money at twice the amount. That is also under PRC guarantee law. Now, English law is quite clear. Seller right to deposits was unconditionally acquired and remain intact despite terminations of the contract. Right? This is my slides on this topic on delivery. Delivery means deliver the vessel.
英国法律规定，在合同仅定在对方违约的情况下，卖方自动获得违约金的请求权。
Now, ship under construction in PRC, right? I say that is drafted in China. You have your own form, okay? And the nature of the shipbuilding in China is a contract of hire work. Okay, what is a shipbuilding contract? Shipbuilding contracts in the PRC is the same as a contract of hire work. Then the materials. What are the materials and equipment within the premises of the 船厂 and have been incorporated or intended to be incorporated to the ship owner, right? Then do they belong to the ship owner or do they belong to the shipyard? And this is something yet to be, it's very academic. We do not know the real answer.
自从2007年以来，中国造船工业协会和中国海事委员会联合起草了一份新的标准造船合同，也就是上海合同，这得到了广泛的支持。中国造船合同的性质类似于承揽合同，这是规定在中华人民共和国合同法第251条。那么造船厂经营住所内注册或拟注册的物料。
Okay, now we talk about ownership of the vessel under construction. All right? Under construction. 在建船舶所有权 Before delivery, ownership belongs to the shipbuilder. Before delivery, right? Ownership belongs to the 船厂. But ship owner can also include a contractual term that ownership of the vessel upon construction is automatically transferred to him in the event of the shipbuilder's insolvency. Meaning that if the shipbuilder's 船厂破产了, then the ownerships of the vessel automatically 转给船东. Now, shipbuilder has a possessory lien over the completed ships. As long as she is in the shipyard, possessory lien, 的权利排得很高, right? And has a strong bargaining positions to obtain payment from ship owner in default of installment payments. Because as long as the ships is in the shipyard, right, the priority is very high, and that is called possessory lien. And this is again unique to 海商法、海事法 possessory lien.
船舶交付前，所有权属于造船人，那船舶所有人可以在合同中约定，在造船人破产的情况下，在建船舶所有权自动移转于他。船舶建造人对已完工的船舶，只要该船舶在船厂经营场所内就享有留置权，并且在托付分期欠款的情况下具有很强的议价能力，就可以从船东处获得付款。
Now, mortgage of ships under construction, mortgage of ships, okay, means that really 在建船舶抵押权, right? As I mentioned earlier, the 抵押权 of a ship owner and a bank is completely different from that of a building or 房地产. Mortgage may be established on the ships under construction, right, in China. Then the provision regulation of the construction limits the mortgagor to the shipbuilding enterprise. To ensure compliance, there can be performance guarantee issued by the bank for the ship owner and refund guarantee by the shipbuilder. Okay, I have said before, the performance guarantee is given by the bank to the shipbuilder on behalf of the owner, 船东. Then refund guarantee is given by the 船厂 to the ship owner. Okay, a non-compliance with delivery date can trigger a serious breach under the refund guarantee. Non-compliance with the delivery date can trigger a serious breach under the refund guarantee, and many Chinese cases involving 中国的船厂 have been the subjects of 海事仲裁庭 cases in London.
在建船舶可以设定抵押权，船舶抵押权登记建造暂行条例第4条规定，抵押权人限于船舶制造企业。为了保证合规，可以有银行出具的船东履约保函和造船商出具的退票保函。不遵守交货期限会导致严重的违反退款保证。为了保证履约，可以有银行出具的船东履约保函和造船商出具的退款保函。不遵守约定会导致严重违反退款保证。
Now, a demand guarantee in PRC. Not an independent contract. If the principal contract is null and void, the guarantee will be the same, as it is considered ancillary to the main contract, meaning that if the main contract is null and void, then this guarantee is also null and void, right? Then foreign shipbuilding guarantee provided by non-financial institution is an external guarantee, and that must be subjected to governmental management and supervision, meaning that if there is a foreign shipbuilding guarantee given by non-financial institution, right, the guarantee is not given by 外国还是国内银行, then if it is an external guarantee, it must be registered in China. Must be registered in China, and this is regulations of SAFE. SAFE 是银行位, I think, governmental management and supervision.
建所给付保函不
Okay, novations and resales. When business is good, in China you have a lot of novations， 就是转来转去，卖来卖去，非常普遍 ，right? That is very common during the times of boom, right? 20年前 ，but right now it's a different story, right? Now a ship owner 船东 can sell the shipbuilding contracts 传给一个地方者 but must have the consent of the shipyard, right? The shipyard 要得到船厂的批准。However, if the shipyard provides a refund guarantee, then the assignment must also acquire the consent of the guarantor, right? If the shipyard has given a refund guarantee to the 船东, then when you do the 转卖, you must have the guarantor permissions and consent that is legally binding.
船东转让造船合同必须要经过作为债权人的造船商同意。
Now, remedies of the shipbuilder. What are the remedies? 1. When the ship owner is in default on its payment obligation, the shipbuilder can claim for liquidated damages, termination of the contract, and specific performance, right? And this is in accordance with 中国合同法167条款。Then the shipbuilder can also exercise its option in having a possessory lien under this too, and can also conduct an auction or a direct sales, right? If the original ship owner refuses to take delivery, then the shipyard can conduct an auction. Now, when the shipbuilding contract is a work contract, then the contract law provides the ship owner with monitoring and inspection rights during shipbuilding. Means the shipbuilding contracts, if the shipbuilding contracts during the process of the shipbuilding, then the ship owner has the right to come to the shipyards to do monitoring and also to do inspection rights. You must understand, a shipbuilding contract, 假如是一个集装箱一艘船 right? You are talking about something like EE, or you have a cruise ships, right? 游轮, it's you're talking about millions.
船舶所有人不履行支付义务的造船人可以要求获得违约金、损害赔偿、合同终止或具体履行。船舶建造人可以通过拍卖或者直接出售行使留置权、船舶留置权。船舶建造合同是劳动合同的，船舶所有人在造船过程中享有监视和检验的权利。
Okay, now next week, next Tuesday, I am going to talk on carriage of goods by sea, and important documents will be bills of lading, 提单, right? 提单, when you study 国贸 or 金融法, you have to know something about bills of lading. Bills of lading are 提单, right? So tonight, I must really thank Feng Ying and Fang Su-Xing 分析得很好. And thank you very much. I will see you next Tuesday. We will be discussing carriage of goods by sea, bills of lading. Next week, next Tuesday, at the same time, that will be lecture 3 of 海商法. Good night, everyone, and thank you very much for attending my class.
Thank you, Professor. Good night.
Good night.